Facts.
MS Nappinai, from a legal point of view, how do you see this particular nuisance, if I can call it that at best?
Yeah, at the worst, it's At the worst, it's nuisance. At the best, for victims, is that the perpetrators may be prosecuted for a criminal offense. So there is one very fine distinction I wanted to bring out, because we use the word voyeurism as it is understood in English, but in law it has a very different connotation, because under law voyeurism is defined as somebody who behaves like a voyeur and violates your private spaces. So if your private parts are filmed, if you are filmed in a private space where you have a reasonable expectation of privacy, for instance, one of the instances you mentioned was in a public restroom. If filming is done in a place like that, then you fall within the provision which is now under the BNS, also Bharatiya Nyaya Sanhita 2, as voyeurism. However, if it is just filming your face or you walking, etc., in a public place, it is not covered under that provision. But as Sahajji already pointed out, just because an offense will not fall under voyeurism, it does not mean that you're not committing a criminal act. You may be violating various other provisions, but that is not contingent on the photography per se or dissemination also. It is contingent on how the content is disseminated, what goes with it. See, the person's intent comes out when there is a very obscene comment along with it, or it's shared in an obscene platform, etc. So that's what decides whether a criminal case will lie or not. So today we are at a threshold where we have laws which falls clearly under, for instance, in the Information Technology Act, you have a specific provision under 66E titled privacy. But that does not mean it covers all types of privacy. It covers what I already mentioned earlier. So we have to evaluate whether we should make just photography per se, or photography with mala fide intent, or photography with mala fide intent added on with the way it is disseminated into a criminal offense, or we are going to give civil remedies to the victims. We need to keep in mind that we have multiple kinds of remedies, and the most important one I want to use your platform to highlight to victims is, irrespective of the nature, when it violates your privacy, you can write to the platforms and ask them to pull it down, depending on the kind of content. For instance, if you're being portrayed in an obscene manner, the platform is bound to remove it within 24 hours, and the maximum can be 15 days. Thereafter, you have a grievance redressal mechanism under the MATI of a grievance appellate committee. So you have two remedies without you having to rush to court or to a police station. I feel these are very critical, because we all know that under Puttaswamy, our right to privacy has been affirmed. We always had it. It's just that the judgment affirmed it. But you need remedies through which you can implement your right, and I'm just giving you some of them.